What do you think of what Professor Tribe just had to say about the Supreme Court and how it's likely to respond?
No, I totally agree with him. If you read that 133-page opinion that was issued yesterday by the Colorado Supreme Court, they basically went through every possible argument against taking Trump off the ballot, pretty much demolished every one of them. I mean, the 14th Amendment in and of itself, just the plain language says that if you took an oath of office that you affirmed that you would essentially protect and defend the Constitution and then engage in an insurrection, which he clearly did. And the court went through all of the evidence and the meaning of insurrection and what exactly he did do that day and what they had from the January 6th committee and what was said by Trump in his own words, even on a tape recording with the Secretary of State of Georgia. I think they're going to have a hard time not affirming the Colorado court. You have to read that opinion. It really answers every one of these objections that have been raised. And it's not just Mr. Tribe. It's also, others who are very conservative lawyers who have said the same exact thing, that they think that this is a very viable issue. And we'll just have to see what the Supreme Court does.
So you say that they provided evidence that former President Trump engaged in an insurrection, even though he has not been charged with insurrection. He has not been convicted of that or anything else, even if he has been charged with a multitude of felonies. That does not matter when you're reading the 14th Amendment. Is that essentially what you're saying?
No, there's nothing in there that says you have to be charged or convicted. I mean, there are basically 4 requirements to be president. One is that you're 35 years old. 2, that you were born in the United States. And if you were born in the United States, that you lived here for at least 14 years. And 3rd, fourth, you didn't engage in an insurrection. Any one of those, you don't require any kind of finding of a civil action or a criminal action. These are all facts that have to be established in order to be to qualify to even be on the ballot. If you don't qualify for any one of those 4, you're not on the ballot.
So if the Supreme Court does indeed read the law that way, even with a 6-3 conservative majority, 3 of these justices were appointed by former President Trump himself. If they do so, what is the implication, not just for Colorado, but more widely for this election, knowing that there are 15 other states that have brought this issue forward?
Well, if they read it and they affirm the Colorado State Supreme Court, he's off the ballot in all 50 states. He is not qualified to be on any ballot in any state. That's why this is a fairly significant ruling. And if the Supreme Court were to go that way, it would be significant. I also might add the fact that he's appointed 3 of those justices shouldn't be given a lot of weight. Number one, the same thing happened in Watergate, where you had 3 justices appointed by Richard Nixon, yet it was a unanimous decision ordering him to turn over the tapes. 2, if you look at just the conservative philosophy here of reading the text of the amendment, of the 14th Amendment, it's pretty straightforward. If these justices are really strict constructionists, they really have no place to go.
Well, and there's the 3 that were appointed by Trump. There's another justice in question, Mr. Akerman, in Clarence Thomas. He, of course, has come under intense scrutiny this year because of revelations about his relationship with Harlan Crow, a billionaire, other concerns as well. There's been a lot of calls for his recusal in certain cases. Do you think that would be applicable here, or do you think he would heed those calls?
Well, he should. I mean, he certainly has a conflict of interest here. In light of his wife's political activity and her involvement in the January 6th situation. There are a number of emails that have come out in the course of this. She was called before the January 6th committee. I think there is enough smoke here that he really ought to be recusing himself from any consideration in this case. In fact, going back to Watergate again, Justice Rehnquist recused himself because he had been involved when he was in the Department of Justice in certain matters and found that it was important that he recuse himself, which is why the opinion there was 8-0, not 9-0.
Of course, this is also not the only case in which that may be in question, because it's not the only case the Supreme Court's having to deal with when it comes to former President Trump. Just today, Trump and his legal team filed with the court asking them not to essentially do what Jack Smith, the special counsel who has brought charges against him related to 2020 election interference in the attempt to overturn it here in Washington. He wants them to fast track this decision on Trump's immunity or not as a former president. Trump's team saying in the filing, the special counsel identifies no compelling reason for this. He's manifesting partisan interest in ensuring that Trump will be subjected to a months-long criminal trial at the height of a presidential campaign. Mr. Akerman, what's your thought on this case in particular?
Well, it seems to me that he's going to be treated like any other criminal defendant. The fact that he's running for president is irrelevant to this. It's a very important case. There's a public interest in getting this resolved as quickly as possible before the presidential election. And I think that's what the Supreme Court is going to go along with. And keep in mind, they're going to be taking just the opposite view, Donald Trump is, in trying to get the Colorado Supreme Court decision up to the Supreme Court immediately and bypassing the circuit court. So you're going to see him talking out of two sides of his mouth on this issue, both issues which are critical for Supreme Court review.
And Mr. Akerman, you just said there as quickly as possible. How quick is possible? Is a March 4th trial really going to happen?
Oh, it should. They should get this all resolved by the middle of January. Look what happened in the 11th Circuit last week. They had an argument on the issue of Mark Meadows being able to remand his case to the federal court. The same issue, that is whether or not what he is charged with doing is within his power and the executive power. Same issue with Donald Trump. It was argued on one day, 3 days later, 49-page opinion that basically denied Mark Meadows' effort to try and get the case moved over to federal court for basically the same reasons that Donald Trump is claiming immunity in this criminal case.